I hereby call the Wheat Ridge Planning Commission for June 3rd, 2010 to order and ask for a roll call of the members.
Dean Goki. Commissioner Goki is absent. George Pond.
Present.
Ann Brinkman.
Present.
John Dwyer.
Here.
Dick Matthews.
Here.
Alan Bucknam.
Present.
Mark Dietrich.
Present.
And Steve Timms.
Here.
The next item on the agenda is the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and I would entertain a motion for approval of the order of the agenda.
I move to approve the order of the agenda for this evening.
I second the motion.
Call for the vote.
Oh. Sorry. Let's revote. The trainee.
We need a new temp agency.
Go figure.
Thank you. That is approved. I would entertain a motion for the approval of the minutes of the May 20th, 2010 meeting.
I move to approve the minutes.
Second.
Call for the vote.
Okay. We'll try it one more time. Vote again, please. Thank you. Why is it not? Cole, can you show of hands? Thank you. We practiced this today, too. So
And Mark's abstain did get recorded.
Pardon me?
Mark's abstain did get
Okay.
recorded.
Good.
Yeah. Okay. This is the time for the public forum for any member of the public to come and speak on a subject not appearing on the agenda. Is there anyone to speak under the public forum tonight? Seeing none, we can go directly into the public hearings and open the public hearing for case number ZOA-10-01, an ordinance amending Article 7 of Chapter 26 concerning off-premises identification signs, community event sponsorship banners, and signs in the public right-of-way. Open the public hearing and ask for a staff report.
Good evening. I'm here to present the staff report for case number ZOA 1001. I'd like to enter into the record the zoning code, the case file, and the contents of this digital presentation. So there's a package of amendments that are part of this case, 3 different amendments to the sign code, which was amended in 2005. Most recently, and in the past few months we've had a couple different issues arise as we've been looking at some development, proposed development in the city, and that's kind of what's prompted the 3 proposals we'll be going over tonight. Those 3 are to allow for off-premise identification signs for a few different categories of large unified developments, to allow for temporary community event banners on public property, and to allow for freestanding signs to be placed in the adjacent right-of-way for the renovation of commercial properties under very specific criteria. So I'm just going to walk through, excuse me, I'm going to walk through the background on the 3 different proposed amendments. The first relates to off-premise identification signs. Currently, the sign code has very limited allowance for what we define as off-premise signs, or signs that draw attention to an activity or business that's not located on the property where the sign is. We have a few exceptions from that rule right now. One is for public information, if there's traffic signs like a detour sign, anything like that. We also have an exception for a category that's called semi-public signs, which are signs used to give information to civic, basically institutions like a church or a club, and they're very limited in size to just 6 square feet. And the final exception is billboards. We have a maximum of 16 allowed in the city, and there's only a certain geographic area they can be in that pretty much relates to the highway. So what's arisen is for some very large unified developments, a lot of times as part of the development proposal, oftentimes it's required by the city, there will be infrastructure improvements that need to be made at nearby intersections or streets based on the impact that's going to come from having such a large development. And we've seen the applicant wanting to be able to put a sign for their development along those infrastructure improvements, but technically right now in the sign code they would not be allowed to do that because where the sign would be located is not within the actual development that's on the property they control. The second issue tonight that we'll be looking at are community event and sponsorship banners. This really has arisen from the Parks Department. They have wanted to be able to place temporary banners on ball fields for quite a while now in the city, and technically that's not allowed by the code because we do have a category for temporary banners, but it's specific that they have to be attached to a building, and the size of your temporary banner is related to the square footage of your building. So if you're on a park or a property that doesn't have a building or has a very, very small one, you essentially can't have a banner. And obviously a huge need here is to be able to place them on ball fields and tennis courts, things like that, where you want to be able to place it on a fence and not be restricted to only placing it on a building face. And then the third topic that's part of this proposed amendment has to deal with being able to put commercial freestanding signs in the public right-of-way. Generally, of course, the code requires people, if you're a commercial property, you need to provide your signage on your property. And generally, I think everybody and staff agrees that this is a solid rule. However, we have some commercial sites in the city, and this really arises when you have a situation where you have an existing building and an existing site configuration that somebody's trying to come in and reuse, where based on that configuration and then also based on unusually wide right-of-way, the logical placement for a freestanding sign ends up actually being in the right-of-way. So we actually have had an applicant or two have come in and had this issue where they'd like to be able to get an exception and get a permit from us to put the sign out in the right-of-way, and they haven't been able to do that. This is an example, this graphic of Harlan Street, and right here we're on a stretch that's near on the 4300 block, but generally kind of north of 38th Avenue. This is a good example of where we run into some issues. So you can see wherever there's a yellow blob is an existing sign, and the red line is the right-of-way line. So you can see there are several existing signs here on Harlan that are already placed in the right-of-way, most likely unknowingly. And a lot of these properties, because of how the right-of-way kind of jags and does some weird things, even though it seems like you would be on the property, you're actually in the right-of-way. And of course, when we were looking at this issue, we did a lot of research on what other jurisdictions allow. And there are quite a few in the metro area that provide the option to get an exception and put a sign in the right-of-way, almost always subject to a revocable permit, with the understanding that it is the public right-of-way, and if the city ever needed to come in, whether it's for a health and safety issue or because they need to do work in the street, it's at your own risk to be putting a sign there. So you basically have to sign a permit acknowledging that. But other than that, you're allowed to construct the sign there. And we actually already have a permit similar to that in Wheat Ridge that Public Works uses when people have a fence or an item like that they might want to put out in the right-of-way. It has a term for 5 years, so if it's something that's more permanent, you need to come in and renew it after 5 years. So that was kind of the summary of what the 3 issues are, and now I'll walk through what our recommendations are, the proposed amendment relating to each of the 3 issues. So the first is for the off-premise identification signs. What we're proposing is to allow these signs in some pretty limited situations for specific development types. Regardless of the development type, in any situation that we'd allow this sign, you'd have to be part of a master sign plan that is reviewed by staff and approved by the Planning Commission. And the sign would have to be immediately adjacent to or on infrastructure improvements that are required for the development. So the 3 types of developments that we're saying would be eligible for this type of sign are a major activity center, which we've defined as a contiguous commercial development greater than 150 acres. So obviously we're talking about an incredibly large development that's going to be a regional draw. The second is an urban renewal unified commercial development, and that's defined as a contiguous development that's at least 7 acres in size, where at least 50% of the building square footage within the development is a commercial use. And the third option is for a large institutional campus, which is defined as a contiguous development over 75 acres with an institutional land use. We're really imagining this is geared towards medical or institutional or medical or educational campuses. So now I'm just going to kind of walk through within each of those 3 development categories what the regulations would be for the off-premise identification signs. So for a large major activity center, we're proposing that there could be a maximum of 2 of these off-premise identification signs. In addition to the previous requirement that I mentioned that you'd have to be on or immediately adjacent to infrastructure improvements that are part of the development. We also have just an overall rule that you have to be within a half mile or a quarter mile of the activity center. The maximum height would be 10 feet, a maximum area 50 square feet. No pole signs allowed. We really like to see the more quality monument type sign. And we also have the provision that up to 1 sign may be a highway-oriented sign if it's within 300 feet of a state or interstate highway. And that 1 sign could go up to 30 feet in height and have a maximum square feet of 200. So the second category are for urban renewal commercial developments. And again, we're proposing a maximum of 2 per development. Again, the quarter mile restriction. For these, we're proposing a maximum height of 10 feet and a maximum area of 50 square feet, and also no pole signs. And the final category is for the institutional campus. Again, a maximum of 2. The quarter mile restriction applies. A maximum height of 7 feet and a maximum area of 32 square feet, and no pole signs. So now we'll talk about our recommendations for the second category in our amendment tonight, which is the community event sponsorship banners. And our proposed amendment here is to create a new category of temporary banners that are only allowed on city-owned property or public school property. And even though it really was the Parks Department that was the initiator for this amendment, we decided it made sense to open it up to any city-owned property. If there were a city event going on, it would allow other departments the ability to put up a temporary banner. And actually it came out of a study session with City Council to add the provision to let public schools have this ability as well, since it's a pretty common thing for if there's a school sports league or something like that to be able to put a banner out, which technically right now would not be allowed by the code if they were putting it out on a fence, for example. So what we're proposing in the amendment is that the banners on city-owned property will be permitted through just an internal process in the Parks Department. They're already looking at doing a special event permit for when people want to do events in parks. And for most of the situations where you'd have an outsider coming in and wanting to put a banner up on the park's property, it would be related to a special event. So that when they were going through the special event permit, they could also apply to have the banner put up. And Parks is also exploring the possibility of allowing people to put company logos and do some sponsorship on the banners as a way to generate revenue. We're looking at a maximum size of 50 square feet, and the time parameters we've proposed are basically you have a little bit of time before the event that it can be up, and then for the duration of the event with a maximum of 4 weeks total. The banners on public school property would be limited to 2 per site, a maximum size of 32 square feet, and the same time parameters would apply. These signs we're not proposing would need to get a permit of any sort. And the third amendment we're proposing relates to the situation where we have some of these unique commercial properties and unique right-of-way conditions where it's difficult to fit a sign that's visible from the street and have it still be on your property. So we're proposing that there would be an option in the code to apply for a right-of-way permit to put a sign in the right-of-way. It'd be the revocable type permit that I spoke about earlier. Unlike a lot of other jurisdictions, which are pretty flexible, we wanted to codify some pretty specific criteria and make it clear this is a very unique exception. So the criteria include that there are no viable alternative locations on site, that the sign is only for a property that has commercial or mixed-use zoning, that the sign is immediately adjacent to the subject property, that this right-of-way is not a state highway. And that's largely related to the fact that we don't control what's in the state highway, so we can't really authorize a permit to put a sign there. We also wanted to put in the criteria that there aren't any immediate plans for widening the street, so that may be partially why the right-of-way is large in that area and cutting into what seems like should be part of the site, is because there's actually an impending plan to widen the street, so it doesn't make sense to invest and put a sign there. It also is required that the sign is part of a site that's not being completely redeveloped, with the understanding that if you're going to scrape off a building and start from scratch and redevelop a whole site, you should be able to find a way to fit the sign on site. As I mentioned earlier, this really is an issue when we have existing site and building configurations that can't really be changed. Another criteria is that there would be no underground utilities except for electricity, because some people might want to light the sign. The sign can't obstruct the sidewalk or vehicular traffic. It can't obstruct our required site distance triangles. It can't be located in landscape buffer or amenity zone between the curb and the sidewalk. It may not be a pole sign. And we also wanted to put in the language to make it clear that the sign has to exclusively advertise the business or operation that it's been applied for, and not have other text and information on it. And then just to kind of wrap up, for each of the 3 different signs, we try to summarize kind of how we think they fit into some overall goals, both from our comprehensive plan, Envision Wheat Ridge, and policy goals that we have as a city in terms of promoting economic development, providing quality services to our residents. So for the off-premise signs, we really think that it's a way to encourage mixed use and commercial development, to allow that option of having 1 or 2 off-premise identification signs. For the community event sponsorship banners, we think it's really a convenience to the community to be able to have those banners up and know when events are coming. And there's also the potential there to create revenue if there's sponsorship on the banners. And finally, for allowing signs to be placed in the right-of-way, we think it's a way to encourage reinvestment in some commercial properties so that people can still have their signage needs met, even if they have kind of an awkward site configuration or a unique right-of-way condition. So with that, I'm done with the staff report.
Sure. I have a few, so forgive me. I just, and I've looked at this, but I may not be reconciling everything between the amended ordinance in the back of this in this document.
Sure.
On number one, I'm just curious how the criteria were developed for the size. For 1, 2, and 3, you've got 150 acres, 7 acres, and 75. I'm just wondering what the process was for coming up with those criteria.
Yeah. For all three categories, a major commercial activity center, a unified urban renewal development, and the institutional campus, we've had an instance for each of those categories where we've had an actual site that wants to do that. So our sizes were primarily based on looking at what an example development that we think it made sense to allow them to do that so that the size kind of fit with them, but then also thinking about other potential developments that would meet that category in the city. So, for example, for the major activity center, we're very reticent to set a standard that would start allowing kind of any large commercial site in the city be able to start putting up signs off of their property. So we tried to make it a very large cutoff because we really think it should be unique to a regional draw. For the urban renewal, that one in particular is related to the urban renewal site at 44th and Wadsworth. They have at least one sign that would need to be off-site because, like, they're looking at one that would be on land that's actually controlled by First Bank for it to be visible from Wadsworth. And as I'm sure you're all familiar with, the site really doesn't have frontage on Wadsworth. It'll have access off of Wadsworth. So again, this is where that nexus between providing infrastructure improvements and being able to put the sign there comes into play. So they'll be making infrastructure improvements all the way up to Wadsworth and building a road. So the concept there being that the sign can be immediately adjacent to that land that they're putting money into to improve the infrastructure, even though they won't actually control the land that the sign is on. And we chose the 7-acre size there, kind of looking at the size of that development, but then thinking about all the other urban renewal areas we have and where we might see commercial development in the future, where there could be a similar situation where you have access off of a major road, but you aren't, might not have frontage on it to be able to get that visibility. And we, especially for the urban renewal areas, since we want to encourage redevelopment, thought that this was kind of one more incentive. And then for the institutional campus, the 75 acres was, partially looking at the Lutheran campus, and knowing that they've expressed interest in doing some signage on 38th maybe, and which is something that wouldn't be allowed in the code now, but we felt like if they made improvements on 38th, like help pay for a streetscaping project or something like that, it might make sense then to allow for 1 or 2 signs there. And but we wanted to open it up to educational campuses as well, and just generally the idea of who knows what might happen in the future if there was ever another really large institutional campus. They also might want that added identification at a major street or intersection.
So I think that kind of answers my second question, which is that there seems to be existing potential applicants with existing properties, and I assume then they would be submitting a master sign plan and going through the process, and just with not as a new development but as an existing development.
Correct. For some of the ones that are interested that are still in the process of working on their master sign plan, this would have to be included in that. For ones that are were already existing, they would have to come in and do a master sign plan. Or if they already have one on file, amend it and have that amendment approved by Planning Commission. And so that's another reason why we felt pretty comfortable with some of these proposed changes, because we think through the process of having to do a unified sign plan, staff has a lot of review, and then obviously ultimately Planning Commission has to approve it, and it'll give us the opportunity to really weigh in on what's appropriate and what's not.
With respect to the Second Amendment on community and event sponsorship banners, specifically with respect to banners and signage on school property, I was wondering if staff consulted with anyone over at the Jeffco School District in particular about the requirements and limitations in terms of size and duration and those other requirements.
Mm-hmm. We actually didn't. I think I mentioned earlier the original amendment proposed by staff is just for city-owned property, and in a city council study session, it was brought up that there's schools that would probably like to make use of this as well, and we don't really want to get into the business of issuing permits and regulating what they're putting on the property. I mean, obviously there are some schools now that probably put banners up on fences, even though that's not allowed, and we certainly don't go out and do code enforcement on them. So the overall intent was actually to kind of give a little more flexibility into what their needs might be. So no, we haven't actually spoken with them, but I guess that's something we could look into to make sure there's no big red lights there.
One of my concerns would be, for example, if you're limiting the duration to, say, 4 weeks, for example, if you have a sponsorship opportunity for the school or the district to make some money on sponsorship of, say, a banner or sign in a baseball outfield or along a soccer pitch or something, mounted on a fence, with visible from the street or other public access. Some sponsors might look at that and say, well, if I can only have it up for 4 weeks, as opposed to, say, the whole season of the sport or for the whole year, you look at the cost of producing the banner versus the payback that you get in terms of increased revenue for the sponsor and visibility. I'd be a little concerned about that short duration when you're talking about school property-based stuff. I mean, I get it in terms of, like, if the school is promoting, say, a fair or a field day or open house or something, an event limitation on time makes sense. But when you're talking about when you're using the language of sponsorship, especially in terms of revenue opportunities for the district or for an individual school, I think you need to look past a specific time restriction that's shorter than, say, an athletic season.
Okay. Yeah, I mean, again, I don't think our intent is to actually be enforcing that time restriction on the school properties, but if we're not going to, then it might make sense to open it up for an entire summer, for example.
Yeah, well, if the intent isn't to enforce that time limit, I wouldn't write the ordinance to have a time limit that you then have to ignore in order to let the school kind of get what they want.
Right. Yeah, again, I think we pretty much took what the regulations were for the parks ones, knowing what their needs were, and kind of, applied the same standards for the school banners, but it might make sense to make those more flexible given the fact that we don't want to have to be regulating and doing code enforcement to make sure they're meeting the time requirements.
Yeah, I mean, I would just recommend a discussion with someone at the district about what they would see as sort of optimal in terms of time limitation or size or whatever whatever conditions currently exist for signage within the district.
I have the same concerns that Ellen raised with regards to the period of time for the banners for a number of reasons. And when I was reviewing this, what I did is I tried to apply certain activities that occur in the city when looking at how signs, banners, et cetera, would apply. So I came up with the Carnation Festival and where they would want to have banners and how they would want to have them, and et cetera. The Lutheran has a 10K that goes, and they right now have little tiny signs, and I'm sure they would like larger signs. I also looked at the Cabela's property as an area where there was going to be large development, and then I didn't bother looking at the 44th Avenue property because we'll cater to that no matter what. So I think the 7 acres is a little arbitrary. I think it needs to be a little smaller because you guys are thinking of existing properties now versus bundling of other properties in the future. So I would even go smaller to say 5 acres versus it have to be 7 acres. And then the 150 acres, I think that's a little big. I think I'm not sure. I did not do my homework and go to see what size the Cabela's property is. But since since that is that whole property is owned by different constituencies, the city has some in there, and then Cabela's has some, et cetera. When it said that the whole property had to be under construction or activity, that concerned me. So I think that 150 is a little arbitrary as well, and I would recommend looking at lowering that amount of acres on that one.
Okay. The 150 was actually, I mean, based on the Cabela site, so they would definitely meet that.
But is that assuming that only the whole site is under development or the main property is under development?
It's just that it has to be under, it's part of one contiguous development plan, and that's all that's required. So it doesn't have to be under development at the same time in terms of construction.
Okay.
But there's over 150 acres that are part of the ODP, so they're part of, it's all one contiguous development.
Okay. Thanks. As I said, I didn't do my homework on the Cabela sign, but I was just trying to apply other activities that occur within the city, and how they would want to advertise. So I would ask to lower the 7 acres. It just seems a little too fit for purpose right now.
Could I interject just a couple things? Don't forget that all of our commercial businesses are allowed to have one banner all the time, okay? Whether they use it for signage or special sales or whatever, each business is allowed to have one banner all the time in addition to their other freestanding and wall signs. The other thing is for the Carnation Festival, we got a little creative with the sign code and were able to find something that applied for them. I believe it was called special event holiday signage, and so we were able to work that into the sign code. I think this whole banner thing is really specifically for the parks and their sporting events primarily. So,
And the 5 acre or the 7 acre cutoff, I think it would be worthwhile for us to take a look at what that might mean if we switched it to 5 acres and see how many more sites it opens up. It's the balance between wanting to allow that flexibility and encourage redevelopment in the urban renewal areas, but also not have it so that there are several sites that can start putting up these signs and kind of cluttering the streetscape.
And I'm not recommending necessarily 5 acres now. I mean, because that's as arbitrary as 7 acres. But I'm just saying, look at it to see what applies now, but also 10 years in the future.
Sure.
And then my other question is, if there were an activity or a club that had a spaghetti dinner or a pancake breakfast or something to that effect, and they wanted to put a sign on city property, then they would just go through the permit. They would go through the city and ask if they could get a permit to put a sign.
Yes,
that-
but likely in those situations, unless the event was also happening on city property, they wouldn't be able to get this is really intended for if there's an event happening, either like a large citywide event, like a Carnation Festival, although they, as Meredith pointed out, they have their own signage situation worked out, but especially for events happening on city property, in parks, for
But
example.
you just said the intent. That's not what the code would actually allow.
Right, and that's where the permit comes into play. If for some reason Parks thought it made sense to let a church put up a banner on the property, they could allow them the permit. They could also deny it.
Okay. It just seems to be a slippery slope, so to speak. I don't have a problem with it. I'm just saying I can honestly see where different activities, different clubs, different whatever will come and want to have a permit, and then you will start becoming a place to do permits for schools or whatever, parks or this park right next to us or whatever. If somebody wants to have a pancake breakfast or a whatever. So, okay.
I have several questions. Sign codes are always a tricky subject, and there's never a good example anywhere. Just to clarify on item number 1, these off-premise identification signs, when you talk about 50 square feet, and 32 square feet, you're referencing per side, according to the table. Is that, so it's really 100 square feet total, 164, is that correct?
Yeah, if you count both sides.
And then on the major activity center identification sign, potentially you're saying 2 allowed, but then an additional 1 perhaps for a highway, so up to 3 they could potentially.
No, one of the two.
So 2 total?
2 total,
One of them potentially.
one of which maybe. Yeah.
And I have a couple of legal questions, and I realize that none of us are lawyers, I don't think. But this issue came up in a similar or another jurisdiction in the metro area about off-premise signs on highways, and I know that Wheat Ridge is a home rule, as most municipalities in the Denver area are. There is some language in the CRS, Colorado Revised Statutes, in Section 41 that talks about additional off-premise signs on federal highways with the Beautification Act and things like that. Has this been run by, I guess, the legal staff with the city to see if that's in conflict, I guess?
Yeah, I mean, I cannot say that they looked at that in particular, but our city attorney has had at least 2 meetings with me on this and reviewed all of the language that's in there. So I would imagine, and did bring up some potential, made, recommendations and changed the language in some cases. So I'll double check to make sure that that's.
I just don't want to actively go against federal law. And then on number 2, the community event sponsorship banners, 2 questions. One is, and again, this goes back to a legal question, right? Schools are regulated by the state in terms of land use and site planning and things like that. Are they also regulated then by the state through signage? Or does Wheat Ridge in this case have the ability to regulate signage for a public school district?
Again, our city attorney said it was okay to put that in there, so I would imagine he thinks we have some grounds.
And actually, as we've dealt with school districts in the past, what we don't, they have control over their siting. However, it's been the city attorney's interpretation that they still have to meet the underlying zoning regulations.
Okay.
So setbacks, height, signage would be included in that.
And then this references Jefferson County schools. It's not available to any private or parochial schools, and I assume that there's some in the city. I don't know if that's a potential issue or limitation that might want to be looked at.
Yeah, we purposely kept those out.
Purposely kept them out.
Yeah. Actually, our city attorney advised that we keep them out, just feeling like to add one more group that we're regulating, and that the public schools met the original intent of these banners, which is on public property.
And then number 3, signs in public right-of-way. According to this table in the back, back here, we currently allow, it looks like, projection signs, which, all right, may extend into the right-of-way with an approved right-of-way permit. So are we already doing this indirectly, I guess?
No, the projecting signs have to be attached to a building face, so they're
Right.
like a blade.
Right?
So it's, I mean, yes, we are allowing it in terms of you can encroach into the right-of-way, but you're not actually,
Not doing a support structure into the
exactly, yeah.
But potentially we have we issued any of those that you all know about from a staff perspective?
We've had a couple, sorry, Sarah, I didn't mean to interject.
No, go ahead.
We've had inquiries in the past from some of those tenants and business owners along 38th Avenue where the buildings are pushed up against the sidewalk. I don't know that anybody has put those up because they're pretty limited in size because it's based on the height of the building. But we have had inquiries in that kind of neo-traditional design context.
And then you reference here it would signs in the public right of way. However, it would add an exception to this rule for rare instances in which existing conditions in right of way. That's a little bit subjective or a lot subjective, and so I just have some concerns about that. And then seeing that image on Harlan, it seemed like there were more than a couple of exceptions. It seemed like that was kind of the trend in certain areas. And so I just wonder.
Well, those aren't permitted signs.
Some of those aren't, they're illegal signs.
Right, they're not allowed to be in the right-of-way right now. And I mean, a lot of them either don't have a permit, so we just don't know. I mean, they just don't have a permit on file at all. I think there was 1 or 2 permits found. Probably nobody knew that they were actually in the right-of-way. We don't require you to have a survey.
I'm just a little bit concerned that rare instances will turn into common instances, and then basically he says if you meet these, you're automatically allowed, and it just seems a little bit lax. I have some concerns with that.
We completely hear you because the staff were really nervous to start allowing this. Most jurisdictions have no criteria at all. They just say if you want to, you can come in and apply to have a sign put in the right-of-way. And our city attorney thought that we actually did a good job of we have a very, very specific set of criteria that are in the code. And if there's just one of those that you don't meet, you don't have a chance. So I think we actually have made it much more strict than most. So it'd be very difficult for it to start becoming the norm. And we've also done we looked at corridors all over the city when we did this. I mean, I showed you the Harlan example, but we looked at others to see, okay, where would this need be and how can we develop the criteria to make sure we're allowing it where we think it makes sense, but also making sure it's not going to be allowed where it doesn't make sense. And there's, I would say, what do you think, Meredith, maybe 3 or 4 corridors in the city where we just have these, for some reason, all of a sudden, in certain places, the right-of-way will just go a lot wider than it is the actual street is. And there are existing signs in the right-of-way, existing parts of the site in the right-of-way. And if somebody wanted to come in and invest in that property and improve it, they wouldn't be allowed to do a sign in an area that looks like it's their property because of the unusual right-of-way width. But it's in very rare instances. And we feel really confident. We spent a lot of time working on that criteria to make sure that it's only in those very rare instances that this can be allowed.
I would just be really concerned that it would just proliferate, right? Businesses, if nothing else, for better or worse, they always want as much signage as possible.
Oh, we totally understand, but if one comes in and they're, for example, anybody on Wadsworth or Kipling, no way. You're on a state highway. Okay, so or Youngfield, all of those are off limits because that's one criteria. Anybody who is doing any kind of complete redevelopment is not eligible. If there's any utility overlap, they're not eligible. There's some pretty big criteria. If there's plans to widen the street. If there's suggestions on other criteria that would help make it even more sure, we'd definitely be open to them. But like I said, we're actually been much more strict than most jurisdictions because we really don't want this to turn into something where business owners think they can come in and any business owner can do it.
And then I assume that as part of this, if this were approved, there would be some type of indemnity clause or things like that, right, if something were to happen?
Yes, that's part of that's already in the language of the revocable permit.
That's all the questions I have right now.
Thank you for the presentation, Sarah. I wanted to first I just wanted to say that I wanted to echo what a number of the commissioners have said, that the criteria seem to have been developed with a specific place in mind that met them, and not necessarily, at least it sounds to me like, with the idea of all the possible places that could apply for signage now or in the near future, which concerns me a little bit. As Commissioner Tim said, I can see businesses coming in, not just businesses, organizations coming in wanting signage that weren't thought of at the time that this was created, but because they meet the criteria, they will be able to get signage. So that was just one thing. I had a question on the section part 1, the major activity center. Since it does appear to be targeted at Cabela's, I'm wondering how come we're allowing Cabela's only to have a sign, it appears, facing either I-70 or Highway 58, but they're not going to be able to have one that addresses both highways.
Well, they actually have a sign on their property that will be highly visible from I-70. So they already have one sign, and you could probably see part of it from Highway 58, although I'm not 100% sure. Meredith might know.
Any sign, any business who is pertinent to a freeway can have a 50-foot high sign. And we have looked at their sign package. I don't think they're proposing anything that high, but they can go pretty high. And
so yeah, they're meeting that need for the I-70 on their site. And then it's really where they're doing improvements that are close to Highway 58 that they would like to put in a sign there as well that can be visible from I-70.
In part 2, that the urban renewal districts, why are they not allowed a highway sign? Considering the current urban renewal district goes along I-70, why would we not allow highway signage for them?
Yeah, we thought about that, and generally we don't really want to be allowing a lot of highway signs. We already have a provision for billboards. And some jurisdictions are phasing out billboards altogether, so you just can't have them at all. And we already allow 16. So to have those and then also start allowing all these highway-oriented signs, we just felt was not, because there's so much urban renewal property, pretty much the entire I-70 corridor is part of the new I-70 urban renewal plan, and we just thought that was a little too risky.
I don't disagree. It just seems inconsistent, and I'm sort of all about consistency.
And just to interject again, remember that any business per the sign code right now within a quarter mile of the freeway can have a 50-foot high sign.
Anybody else? Alan?
I just have something. It's not well. It's tangentially related to these three key amendments, but it does affect. It does relate to the modified language that you've got here in the ordinance for pole sign. The language as you proposed it says that a pole sign is a sign which is affixed to or mounted on a freestanding wood or metal pole and anchored in the ground. I would suggest removing the words wood or metal, just looking towards the prospect of, say, a plastic or composite pole or something. Why give people a loophole that they could sail through and say, well, hey, it's not a wood or metal
plastic,
pole.
Yeah.
It's 4-inch PVC. A minor. I mean, it's kind of a minor thing, but if we can get rid of that, now, why not?
Yeah, I think that's a good comment. Thank you.
Anybody else? Steve?
I have one more follow-up, and this isn't directly on these three issues, but it is about signs, since we're talking about sign code. I looked through the sign code, and I found nothing in there about the removal of signs if a business closes. Is there anything in the current sign code? that I was unable to find? Because there's signs on 30th Avenue.
I can't cite the exact section, but there is a provision that after a business closes, I think within 60 days, they're supposed to remove the signage. It has not been common policy for us to go out and do that, primarily because a business owner typically invests quite a bit of money in the sign, and a lot of times you have tenants that come and go, and so is it reasonable to ask the business owner to remove a sign once his tenant moves out, knowing that the next person who comes in will want another freestanding sign? So it's in there, we just haven't really enforced it because of the business owners.
Thank you.
I do have like 5 or 10 more. No, it's because this is so engaging. I didn't finish my questions from before, so I'm sorry. Is there a mechanism either for staff or for commission variances? Obviously, a lot of these things, especially in section number 1, you could see where there might be instances where either the quarter-mile distance or the acreage, there could be a good reason, for instance, case by case, to make a variance. Is there a mechanism in the ordinance for us to do this, other than what I see, which is that we can, that as a commission we can allow bonus square footage to signage? That's the only thing I saw in here.
Yeah, actually, that's a good point. I'm glad you brought that up because I had forgotten. When we were trying to pick some of these parameters, like what the cutoff is for size and area, keeping in mind that all of these off-premise signs would have to be part of a master sign plan. There is language in the master sign plan that allows for flexibility that Planning Commission can approve from the standards. And if I can find it, I'll read it to you.
And I have another comment, sorry. Well, if Sarah's still trying to find that. George, you weren't around last September, but we did a master sign plan for Lutheran Hospital, and it was one huge variance because of their particular needs.
So I think it's actually right after the language you saw. It says you can provide a bonus for a well-designed plan of up to 50%. And then it also says, or you may permit signs in locations other than normally permitted.
Thank you. Yeah. I got hung up on bonus, obviously. So the sponsorship is, I'm just curious because it's interesting both for how would the Parks and Rec Department deal with sponsorship? Is there a mechanism for dealing with sponsorship and taking revenue and any restrictions? Or and obviously, going to Alan's point, I would assume, because many school districts do have different ways of dealing with that Jeffco schools may have different opinions as to what's okay or not okay in terms of sponsorship, corporate or otherwise. And so I'm just wondering whether or not that was a part of this. I assume you're leaving it in this language completely up to the Parks and Rec Department to make a judgment as to what they're going to allow or not allow, how they're going to take money, et cetera.
Yeah, they're developing their own internal policy on how they want to address that, and we've purposely left that out of this document.
And then just last on item number 3, I'm not saying I'm a proponent of pole signs, wooden, plastic, or otherwise, but it's an interesting thing to kind of force a sign down to the ground, and in some of this area, and it obviously makes it a little bit more different. In some ways, a little bit more permanent, and I'm just curious is that part of the architectural design standards to not allow pole signs? And forgive my ignorance, that would be. Is that it? Okay. It makes it. Frankly, I think you're any new sign in the right of way then has to be a monument sign. Is that a correct statement? That's odd to me. That's it. Okay.
There are no other questions. I have a couple of questions and comments that, like Commissioner Pond and Brinkman, I also am uncomfortable with the acreage in section number 1. It seems to me when there is only one site in the entire city that reaches those eligibility criteria that we are getting dangerously close to quasi-judicial. And probably there should be at least 2 or 3 sites in the city that would meet those eligibility criteria. On the comment on why parochial schools are not included with Jefferson County schools, can you give us about a 2-minute summary of the Religious Use Act and how that affects what we're doing?
No.
Meredith?
Sorry.
Religious institutions are considered quasi-public, just like any sort of government building falls within that category. Typically, they're in residential zoning. They do have their own sign restrictions as far as freestanding signs, what they can put up, how big. It's pretty limited because typically it's not in a commercial area. It's usually residential. Okay? So that's the first thing. Of course, then we don't regulate any content of the signs. There are First Amendment rights that have to be protected, and so we do not regulate content unless it's dirty, X-rated, or offensive in some other way like that. So, not sure that answers your question exactly, but
certainly there are federal rules that restrict the use of religious sites, religious signage.
not sure.
Yeah, okay. And the other one is just idle curiosity. For signs in the public right-of-way, where do bus benches fit into that category?
Oh, that's a good point. I should have mentioned that. We actually do have a very specific part of the sign code that addresses that and allows bus shelters and benches in the right-of-way. And Public Works administers that. They work with RTD. If RTD has a application, then there's this one exception in the code for bus shelters and benches.
Does that conclude your presentation?
It does.
The next would be if we have any members of the public that would like to testify. No one would like to testify? Okay. A motion would be in order, and I should point out that I think that there are a couple of potential conditions in that motion. If there wants to be any discussion of those potential conditions.
Mr. Chair, I'm not ready to make a motion yet, but if we do make a motion, I would propose that perhaps we could break out. Right now it's one motion. I'd like to see it broken out, each one. That might give people a little bit more flexibility in making their decisions.
Are you moving to divide the question?
Sure.
Okay. Is there a second for that?
I would second it.
Call for the vote. Okay, we are going to vote on those 3 different items separately. What type of discussion would you like to have before you make a motion?
I'm struggling with this whole balance between community aesthetics and the rights of businesses and the ability to adequately, broadcast your business in an effective way. As I referenced earlier, no sign code is 100% or even 90% or even 80% great. I do have some concerns over the increase. Typically, cities nowadays are restricting signage rather than increasing it, and I think we do need to be flexible. However, I'm not quite sure if all of these are the way to go in these particular instances. I know that along 38th Avenue in particular, I just see one business doing one thing, and then the rest of them see it, and before we know it, we've got signs up and down the corridor, in addition to our temporary ones and illegal ones, and et cetera. So I have some concerns over several of these. As a result, I will not be voting in favor of number 1 and 3.
Okay.
Is there anything in particular that you could point to in sections 1 and 3 that could guide us and staff in making it an ordinance that you would vote for?
I have similar concerns on, again, if for some reason number 1 didn't go through, perhaps the 3 sites in the city could always rezone and incorporate these ideas into their zoning, right? I think that option potentially could exist.
I don't, just to clarify,
You don't think that's possible?
no, it doesn't,
We can't do sign regulations through zoning here?
not when it's off your property. If it's in the public right of way or off property, that's,
Yeah,
That can't be
I just have a
changed.
concern that there's going to be political pressure for staff on some of these things, right? For paying for infrastructure improvements, whether they're public or private. If Lutheran Hospital pays to do a flower bed at 38th and Sheridan, they get a big sign there. And we had all these at our sign code hearing last fall, right? A lot of people came forward one after another about the existing sign that wasn't part of the case, right? But about how bright it was, and these are in residential areas and things like that. So that hits me the wrong way. And then adding additional off-premise signs, potentially in a billboard fashion, not a typical billboard, but acting as a off-premise. I feel like it's a little bit too broad for my comfort, I guess. That staff could be put in a tough political situation on where the infrastructure improvements beyond the boundaries, what exactly the impacts. I could see that going a little bit too far. So I don't know what could be changed on number 1 to make me comfortable with that. Number 3, I'm fine with the projection signs. I think that's great. I think that's a great planning tool. I think that makes sense. As Commissioner Pond indirectly stated, by not doing pole signs, you're doing monument signs, which typically are more expensive than pole signs. So in a way, we're de facto giving permanent signage to these businesses, even though we're only giving them 5 years with the ability to extend that time. So I'm not saying I want to see a pole sign. I think visually they're more unattractive, but it's like an indirect message, I guess, there. So I'm not quite sure there's anything that could be done to change my philosophical objection to 1 and 3 regardless. Sorry.
I have to ask an educational question. In other words, I need to be educated. If we were to vote to approve any one of these 3, does that mean that the language that's drafted here in this packet under these ordinance then is ratified and is not up for any amendments or anything like that? Do we have to, in our motions or conditions, amend any of the language as we go through this?
I think that if you have specific provisions you have a problem with, you should go ahead and point those out. Of course, when we go to City Council, we include the minutes and the motions and so on and so forth. And it's unfortunate that we do have a couple folks who are super impacted by number 3, these private property owners who have just invested really a lot of money in rehabbing a specific property, and they are at a loss with what to do for their signage. They have no visibility. They can do a wall sign, which ends up being parallel to the street, and they need something perpendicular, which then goes in their parking, and they don't have room. So it's unfortunate that they didn't show up to testify, so you could hear a little bit of what we hear. But anyway, yes, everything would be forwarded to City Council with your recommendation to see how they want us to proceed.
So is anyone interested in making one of 3 motions?
Could I ask for a break? Could we have a 10-minute break? And we could reconvene at 8:15?
There's a motion for a 10-minute break.
We could ponder. Are you okay?
Is there a
Are
second?
you okay?
I just want to make sure we also have time for our mixed-use zoning and,
We could be here till midnight.
okay.
I'll second the motion.
Call for the vote.
We need some ponder time.
We are on break. We're reconvening the Wheat Ridge Planning Commission for June 3rd, 2010. And I think where we were is we have decided that we would like to have additional discussion of each one of the 3 items before a motion. So I believe item 1, the off-premises identification signs, is up first for additional discussion. Go ahead.
So I will say that I think that the size criteria I may have some discomfort with. However, if the variance process that's stated in the ordinance in that last paragraph allows for alterations for that, and there's a process for that, then I'm less concerned about the acreage requirements, the distance requirements, and the square foot requirements. So I guess I don't have as many reasons to vote against this, as long as that part of the ordinance allows for us as a commission or as staff to apply variances to these.
Okay. Additional discussion of 1?
My only concern is with regards to the acreage, the arbitrary nature of 7 acres, 150 acres. I hate making a decision on what the appropriate size is for this. I don't want to design on the dais. I've done that in my life, and I get in trouble. So, and we get in trouble. So, I have some concerns about that area. I will tell you that. Yeah, that's all.
Okay. Any additional, Alan?
I'd just like to echo Commissioner Brinkman's reservations about the acreage restrictions or specifications on item 1. The fact that these specifications apply to one or at most an extremely limited number of developments in each case, I'd really feel more comfortable with it if we had maybe a map or a listing of multiple applications multiple sites where this item would be applicable.
Okay. Any other discussion of 1? Oh, John?
I have the same reservations that my 2 previous colleagues had. And in addition, the entire first section to me seems targeted at a very limited number of places, almost as if it's designed to circumvent code regulations rather than to broaden them, which, as Commissioner Matthews says, seems very close to me to a quasi-judicial activity. As I brought up before, why no highway signage for the urban renewal, but you include it for the major activity districts? That sort of thing bothers me. I'd like to see those issues ironed out, and again, that we have a larger number of properties that would be able to take advantage of some of these. It doesn't, perhaps because we didn't get to see it first, it doesn't, before we saw it here, it doesn't to me seem completely ready for prime time, to use a colloquialism.
Any additional comments? Steve, we're ready for a motion.
Mr. Chair, on issue number 1, off-premise identification signs, I move to recommend denial of the proposed ordinance amending Article 7 of Chapter 26 concerning off-premise identification signs.
I second the motion.
Second. Call for the vote.
Wait.
Discussion? Nope, you just need to declare the votes. Okay, call for the vote. That means that it will be a recommendation for denial, but with the comments that were made by the commissioners. I think that's the result we wanted. Yeah. Okay. The section number 2, community event sponsorship banners, discussion of that.
I have a little bit of discussion. I'd be in favor of item 2 with the condition that staff consult with the Jeffco School District to create appropriate size, time, and event restrictions for banners placed on district property, and to include the district's recommendations in any final specifications regarding the same. I think this would really allow the district to meet their needs better in terms of signage, banners for events and sponsorships, and maximize the opportunity to generate awareness of the school programs and so forth, which sounds like the intent of the amendment.
Any additional discussion? John?
Just a quick comment. I'm not opposed to that. My only question would be if after discussions with the school district needs different requirements, that would then be a code amendment versus just entering that into the code. Is that correct?
My understanding, because I had checked with Ken on this earlier, depending on comments that we got tonight, if we could still change the proposed code language before it goes to City Council. And I was told that we could do that. So we could take your recommendations tonight, talk to the school district, and if changes need to be made, make those now before it gets adopted, so you don't have to amend it again. Just amend it once with the right language.
So if we don't have the right language now, we shouldn't move to approve the amendment as written. We should.
No, you're recommending that they go out and talk. I mean, remember, we're just making recommendations.
Okay.
So you're recommending that they incorporate whatever they learn from going to the school district. And as long as we say that they should incorporate those modifications to whatever language goes before City Council, I would argue that, we're okay, that it doesn't have to go before us.
Okay. Yeah, that's what I thought too.
Additional discussion on that?
Did somebody, I thought off time, I thought somebody had some concerns about not including parochial schools.
I do. Having said that, the staff presentation seemed to take into account that they had thought about that and specifically left parochial schools out for legal reasons. I'm uncomfortable with that personally, but I'm not a lawyer. And so I can't actually comment on it, but it doesn't, to me, seem like the right way to word it. I'm not going to vote against it on those grounds, simply because I don't have the legal background to actually comment on it.
Okay. Could we entertain a motion, Alan?
Yes, I would move to recommend approval of item 2 regarding community and event sponsorship banners, amending Article 7, Chapter 26, with the following addition: that in order to allow the Jefferson County School District to meet their needs and maximize the opportunity to generate awareness of school programs, events, and for sponsorship opportunities, staff must consult with the Jefferson County School District to create appropriate size, time, and event restrictions for banners placed on school district property, and include the district's recommendation in any final specifications regarding the same.
For a second?
I'll second the motion.
Any discussion of that motion? I call for the vote. Passes 7-0. Discussion on the third part of that, signs in the public right-of-way.
I have just a little bit of a question. And I probably should have directed this to staff when we had you up here. What happens to those existing pole signs or other signs in the right-of-way? For example, that whole section between 38th and 44th on Harlan, are we then going to be basically including them under this sort of exception, or are we going to be, if some of them are pole signs, have to go back to them and say, guess what, you've got a pole sign, it isn't the right of way and we would allow it, but it's a pole sign. I'm just a little unclear as to how item 3 addresses those pre-existing, the bulk of the pre-existing signs.
I had assumed they would be legal non-conforming uses, but I would like to verify that.
No, we haven't had the discussion, although yeah, I mean, they would, my initial action to would be they'd be legal non-conforming because they haven't gone through this process at all, so they're still not conforming signs. And, you know, our intent was less to try and solve the issue with those signs, like go in and ask them to be changed to monument signs and go through this process, and more just so as some properties in that area redevelop and are invested in, so that newcomers who are playing by the rules and trying to get a permit could also have a sign visible from the street.
Okay, thanks.
Is there additional discussion on that? I would entertain a motion for Section 3, signs in the public right-of-way.
I'll make the motion. I move to approve amendment to Article 7, Chapter 6 of the Wheat Ridge 26. Did I say 6? Sorry, 26. Signs in the public right-of-way as written.
Is there a second for that?
Second.
Any discussion of that motion? I'll call for the vote. And that passes 5-2. Okay, that concludes the public hearing portion of the meeting. And the next item on the agenda is a study session. And I would like to adjourn the public meeting and go directly into a study session. Is there a motion to that? Yeah, we need to move to do that.
I move to close the public portion and go directly into study session.
Second.
Call for the vote. Okay, and that passes 7-0. Okay, we are ready to go off the air and go into the study session on mixed use.